At the Maine Supreme Judicial Court on Wednesday, York County Assistant District Attorney Patrick Gordon argued that customers of prostitutes have an expectation of privacy similar to lovers who meet behind closed doors. The prosecutor was looking to reverse the decision of Justice Nancy Mills to dismiss 46 invasion of privacy charges against Mark Strong Sr. in the Kennebunk prostitution case.
No one would argue for a minute that that person didn't expect privacy there. So why would it be any different if money changed hands? It's the exact same behavior. It's the exact same relations. It's the exact same amount of vulnerability. It's the exact same thing that our society has sought to protect. Privacy we've protected. People engaging in these type of relations in a private setting together.
Mr. Gordon, is it exactly the same thing when money changes hands?
The behavior is entirely the same.
But are the expectations of the individuals involved in the behavior the same? In your hypothetical, you have voluntary social companions who have chosen to go behind a locked door and have sexual relations. In the case before us, the state alleges that the people coming to the place of prostitution were there for the purposes of engaging the services of a prostitute.
That's correct.
Isn't that a world of difference under the statute? Are you asking that this court finds that a person who goes to the place of business of a prostitute is a person that the legislature recognized as someone who is entitled to privacy with a reasonable expectation that there will be no surveillance?
Yes, Your Honor. And I think to do otherwise would produce inconsistent results. As I stated in my initial speech here today, what if they weren't involved? What if money never changed hands?
Then it's a different case, which is what criminal law is all about, isn't it?
It is.
Strong's attorney Daniel Lilly reasserted that people charged with engaging a prostitute should have no reasonable expectation of privacy.
They're saying a reasonable right to privacy during a sexual act with a paid prostitute is protected by the criminal law in Maine. We submit that the Superior Court correctly determined that patrons of prostitution had no reasonable and have no reasonable expectation of privacy when they visited the commercial establishment, which is the offer of proof, for the sole purpose of engaging in illegal activities.
The High Court made no indication on when it might rule on the appeal.